So I want to welcome everybody to the Future of Video Competition and Regulation, hosted by the Duke Law Center for Innovation Policy. I also want to give a shout out to Brian Schwab from Venable. Venable, kind enough to host us here, thanks in no significant small part to a Duke connection. So any of you all who really don't like Duke, then that's the reason why we got this room. So those of you who don't know, our center focuses on important issues in innovation, not about what's happening immediately. Everybody's already locked in on that, but also not what's happening in some imaginary future years and years away, what's on the near horizon. And the conference today is prime for that, because the video market has changed dramatically in the last few years. It was actually less than a year ago that HBO decided to go streaming. People said it would never happen, and then it happened, and of course CBS as well. We have companies like Verizon offering skinny bundles, getting sued by ESPN. We have millennials not knowing what it means to have an MVPD subscription. And more broadly, video consumption has changed. Viewers are moving not only away from linear TV, they're moving from traditional watching of traditional video. And maybe the notion of what is traditional video itself has changed. But we have a regulatory system that is premised on the notion that MVPDs are important, are their own market, and need their own regulations, and need horizontal concentration limits, and need vertical integration limits because of concerns about monopsony power, and need retransmission consent regime, et cetera. And the obvious question here is everything changing? And if so, where should that lead us as a matter of regulatory policy in the future? So I'm not going to talk about that at any length, because we have a stellar lineup of people who are going to talk about that at some length. So you all have the schedule. We're going to have a speech by Bill Baer, and then he and I are going to have a conversation, and then we're going to have 3 panels, each of which panelists will talk among themselves, throw it open for audience questions, and then at the end, Frank Pallone will come in and give a speech and also tell us who the next House Speaker is going to be. Without any further ado, let me introduce Bill Baer. My introduction will be short and sweet, because Bill doesn't need any introduction. He shouldn't need any introduction in an audience like this. He's been doing antitrust policy for decades at Arnold & Porter and the FTC, back and forth, and now as the Assistant Attorney General for the Department of Justice. So translation is, he knows what he's talking about. So without any further ado, let me welcome Bill up to the stage.
Good morning, everybody. Stuart, thank you. I always think the introductions of me need to be short, because I am. But I know, Stuart, your center has made a real contribution to these policy debates. I know there are many people here in this audience who are heavily involved in these issues, thinking through where competition needs to go. I know John Nectarline and John Salet are here, my colleagues, and I'm sure it'll be a great panel later on this morning when Howard Shalansky, who also seems to know a little bit about this area, comes in. I'm honored to be the kickoff speaker, and I want to begin by echoing some of the points that Stuart made. It is striking to step back and consider how innovation and competition have reshaped not just how, when, where we receive video content, but the content that's available to us. Our options today are, you all know this, bear no resemblance to what was available to us when we grew up, and for somebody of my generation, that is an even more profound difference than for most of you. I was there when you had a couple of broadcast local stations, and saw the move to cable satellite. We have hundreds of specialized channels available to us today. I recall those primitive and often futile efforts to use a VCR to record something, and now we've got DVRs, on-demand viewing, and you look to 15 years ago and email, the status of email then, from plain text messages, we've gone to rich HTML text, images, video. It is really remarkable. And as Stuart said, with regard to video programming, the streaming option is transformative. Programmers now have the internet as a real alternative to distributing. It's an alternative to the traditional broadcast, the satellite or the cable provider. This over-the-top via broadband increasingly competes with what consumers used to access solely from those other options. And you look at what's going on with programming. In 2009, there were just 2 scripted original series delivered exclusively through online services. Last year, 2014, there were 27. This new distribution option coming over the top lowers barriers to entry for non-traditional content. So YouTube, esports have options they otherwise would not have had. Established programmers can provide more tailored services. As Stuart said, you've got various programmers, CBS All Access, HBO Now, offering or expanding their services. ESPN3 is one of the latest additions to all that. And consumers, we all know this, are just loving it. They're embracing these new options. More than half of our TV viewing is time shifted in some way. More than half of each evening's internet traffic is devoted to video content. So the internet in the evening is just filled with people streaming content. The estimates are that within the next 4 years, the monthly video consumption via the internet will increase 400%. And that pace of change seems to be accelerating. It's as though, we've got a video equivalent of Moore's Law working. Moore's Law, the prediction that the number of transistors in a dense integrated circuit doubles every 18 to 24 months. That seems something like that seems to be at work here. It's quite remarkable. And competition has driven much of these developments. Antitrust enthusiasts, and you're looking at one, like to call this disruptive innovation. And some of that innovation is coming from incumbents who are smart and nimble enough to look down the road and see what's happening. But there are new entrants who deserve a lot of credit too. Netflix, Amazon do confront the incumbents like CBS and HBO and force them to rethink their model of how they can best provide their services to consumers. So what role does competition policy and antitrust enforcement play in all of this? Well, you start with the premise you don't interfere with those parts of the market that are working. That's axiomatic to sound antitrust enforcement, to sound competition policy. But it's equally important that enforcement and policy look at market imperfections, look at bad conduct, look at mergers that threaten to create or enhance market power. And if you look at the markets we're addressing in the video area today, there are some characteristics of the landscape that complicate competition, require some efforts to look at whether antitrust enforcement is needed. One characteristic stands out, and that's the fact that today most consumers do not enjoy competition for high-speed internet access. As Chairman Wheeler put it, as bandwidth increases, competitive choices decrease. 70% of all homes have access to only one or to no broadband provider that meets the FCC's new standard for high-speed internet. And ensuring that consumers have access to high speed is a significant public policy objective of the FCC, and for good reason. Consumers deserve access to the content and the method of delivery that allows them to get the best quality where they're going to invest their hard-earned dollars. You'll see as I talk today, I'm going to talk a lot about the FCC. It will look like a huge suck-up move, and it is. The relationship between competition policy, as we look at the Antitrust Division and the FCC look at it, they are closely related. And in the Obama administration under Julius Janikowski and under Tom Wheeler, we have tried to work closely together to coordinate policy. And it's important. We know there are substantial barriers to entry and expansion for new broadband services. In some areas, there are telephone companies or others have built high-speed fiber services that put competitive pressure on cable ISPs, but building fixed broadband networks requires huge sunk investments. You all know that. And the economics may not work in many areas of the country where population density doesn't support that investment. And today, wireless is too capacity constrained and costly to provide a meaningful alternative for consumers looking for high-speed internet access. So the only access from most consumers today is the cable company. And that's the same cable company that derives significant revenues from its cable television content business. That means as online video distribution increases, the cable companies have both the incentives and the means to use their gatekeeper power to slow innovation to protect profits. In this way, the high-speed internet market and the video distribution market are inextricably linked. If we can overcome this bottleneck program through private innovation, through sound antitrust enforcement, and smart pro-competitive regulation, the benefits are potentially much greater than just creating even more video to watch and more ways to watch it. If we can prevent cable companies from exploiting their bottleneck, a more competitive video entertainment market will also spur more broadband competition. With a robust array of online video options available to consumers, new broadband internet providers like Google Fiber can compete more effectively with the incumbents' double play and triple play packages. This makes it more attractive and practical for new fiber entrants to make the significant upfront investments needed to complete head-to-head with the cable companies, who in most areas, as I said, are the only one able to provide high-speed internet service to consumers. This feedback effect between competition in the video market and competition in the broadband market creates the potential to unlock the virtuous cycle of innovation and broadband investment that the FCC has championed. And so when we speak about preventing broadband providers from using their control over bottlenecks to hamper video competition, we're also hopeful that this vigilance may lower barriers to entry into broadband itself. The FCC's National Broadband Plan put it that broadband is the great infrastructure challenge of the early 21st century. It enables improvements in healthcare, education, energy, and the Internet of Things. Tom Wheeler said it well when he said broadband internet is part of the table stakes for our economy and necessary to make us the innovation leader for the 21st century. These tensions in the video and broadband markets present challenges for antitrust enforcement and policymakers, to be sure, but they are challenges we faced in other markets. And to take an example not too far away from what we've been talking about, and we'll be talking about this conference, we take a look at wireless, which shares some, well, not all, of the obstacles to achieving effective competition we see in high-speed broadband. Like the bottlenecks in high-speed, wireless broadband competition is limited by spectrum availability. And just as video and broadband providers must adapt to this Moore's law-like increase in the pace of change, wireless providers must grapple with wireless data consumption increasing at near exponential rates. Now, given the upfront costs of wireless infrastructure and spectrum, just like building out a cable network, it's not surprising that wireless carriers here and throughout the world have been tempted to consolidate and to emulate the more cozy market structure of their earthbound internet service provider counterparts. Due in part to our experience with bottlenecks in video and broadband, we've been wary of the wireless carriers' efforts to combine. Such efforts often don't lead to the promised results, but instead simply result in higher prices and less innovation for consumers. That's why the FCC and the Antitrust Division of the Justice Department moved to block the AT&T-Mobile combination in 2001, and more recently, when our friends at Sprint and T-Mobile publicly suggested that it was time for them to reduce competition in that market from 4 to 3, it was a skepticism quite widely expressed of the Department of Justice and the FCC that caused that idea to be, it didn't go back to the drawing board, it actually went totally off the drawing board, I think. So today, consumers are continuing to benefit from 4 choices among carriers, increasing flexibility in their cell phone plans, a competitive dynamic that did not exist when AT&T T-Mobile proposed to combine, and that was threatened when Sprint thought it could come in and pick up T-Mobile on the cheap. This vigilance against mergers that would reduce the number of competitive options for consumers is one step. So vigilance is one step. But we also recognize that the limited availability of high-quality spectrum presents a comparable continuing bottleneck to competition. Just as historically the dominant cable companies control the pipe to consumers' home, the large wireless carriers reap rewards from controlling the lion's share of the scarce and essential pathway to mobile devices, spectrum. For that reason, we've supported the FCC's efforts to make more spectrum available and to do so on terms that will promote opportunities for smaller players and new entrants to challenge the well-entrenched market leaders. Our enforcement and policy efforts in wireless are instructive, but as I said at the beginning, we understand that video and broadband markets present unique challenges. Video and broadband providers not only contract downstream with residential customers to sell service, they also bargain upstream with content companies to make that content available to their customers. For example, established networks, Disney, Fox, newer providers like Netflix depend on cable companies like Comcast to deliver their content and to enable them to sell ads or obtain subscribers. In that sense, the cable companies are essential gatekeepers to what customers watch and how they watch it. If content companies don't think they have a way to get their product to consumers, they won't invest and they won't innovate. Or if cable companies use control over the broadband pipe to increase the charges streaming services must pay to reach customers, those new services may be less effective in competing with traditional video. So these critical facts, these analytical concerns, is what led the Justice Department and the FCC to take tough stands on the now abandoned Comcast-Time Warner merger. For the most part, obvious, Comcast and Time Warner did not compete downstream to serve the same households. Most consumers were still going to be left with only one high-speed provider, with or without the merger. But for both agencies, that was just the beginning of the analysis we thought we needed to do. We needed to look upstream at the other end of the pipeline, where Comcast and Time Warner do and compete. The question we asked was pretty basic. Would the merger make it more likely that a combined Comcast and Time Warner would act as a gatekeeper between content providers of all kinds, whether you're thinking about Fox, CBS, Disney, YouTube, whatever? And would it be a gatekeeper between them and the consumers those content providers are trying to reach? After a lengthy investigation, and John said it was lengthy, right? Yeah. The answer to that question was yes. Putting Comcast and Time Warner together risked disproportionately increasing the merged firm's bargaining leverage. The combined firm would have ended up with 30% of all pay television households. It would have had the majority of households in the largest cities that are most important to advertisers, and it would have controlled access to nearly 60% of the high-speed broadband subscribers in the U.S. This leverage would have left Comcast with too much control and with too few competitors when shaping the future of video competition and broadband internet service. Coupled with Comcast's understandable incentive to reduce the competitive threat posed by the over-the-top programmers and streaming services, consumers would have been at risk. Now, in discussing competition and its important to innovation in video markets, as I said, we do share space and, thank goodness, a point of view with the FCC. Tom Wheeler gave a speech shortly after he became chairman that his mantra has been consistent and concise. He said that mantra is competition, competition, and competition. Now, as you might imagine, that particular call to arms resonates with antitrust enforcers, with people who do what I do at the FTC and at the Antitrust Division. But we both agencies recognize that enforcement is not the only tool available for dealing with anti-competitive market structures. There's also a role for smart, pro-competitive policies that can help prod change when competitive pressure is missing, or protect competition in situations that the antitrust laws can't easily reach. One is the FCC's decision to update its benchmark for broadband download speeds to 25 megabits. Higher speeds are necessary for consumers and businesses to take full advantage of all the things the internet can do. And when you change the definition of high speed, and you look at something like Comcast Time Warner, it just puts it all in a different perspective. So that change was an example of sound public policy adjusting to the reality of marketplaces. And the FCC also took smart and measured action to protect competition with the Open Internet Order. That order set out some simple, bright line rules. Broadband providers can't block access to lawful content, they can't throttle lawful content, and they may not take money to favor some content over others. The order, which the Justice Department, the Antitrust Division, is proud to help defend in court, effectuates the public policy that Congress mandated in 1996 by ensuring that cable companies or other broadband providers don't disadvantage competitors offering consumers video services via their broadband connections. This help protects consumer choice, ensures that incumbents that both sell both video and broadband do not use their control over broadband to suppress competition in the video programming development market. Sometimes a related issue, the concern with undue restrictions on competition stems from incumbents seeking laws and regulations that would impede opportunities for rivals to challenge their control over the pipeline. You can see that debate playing out in the efforts by some internet service providers to seek state laws that would preclude local communities from encouraging local alternatives to local broadband monopolies. The FCC, through the municipal broadband order, targets those obstacles in order to allow municipalities to promote competition, to promote the expansion of broadband availability. This helps bring greater competition to exactly the part of the industry that needs it most. It deals with the one pipe problem. So I am pretty much where I began, still short. The future of video competition should be left for the market to decide. Our role as antitrust enforcers and competition advocates is not to pick winners, not to pick losers. Our job is to make sure that existing bottlenecks are eliminated, that mergers don't create new ones, and that our enforcement and policy efforts let competition thrive and innovation continue, all for the benefit of the American consumer. Again, thank you. You've got a great day ahead of you, and I congratulate Stuart on putting it all together. Thank you.
So I'm going to continue the conversation for a little bit longer. Bill, with your indulgence, I'm going to assume I have your indulgence for that purpose, by the way. And I just want to follow up with some questions. So you're talking a lot about, I'm interested that you're talking about video, I guess I should turn this on video and broadband markets. And I'm interested in you spinning out a little more how you see those as being related to each other.
Well, it's sort of a classic antitrust concern. If you have a bottleneck, a one-pipe problem with somebody who's integrated and also is integrated into the video content market, there is a risk that people who are developing competitive video alternatives, if that person controls so many of the pipelines into so many homes, that will suppress video competition. That was the development of alternative sources of video. That's one of the concerns we looked at in the Comcast Time Warner matter. On the other hand, if those video, or related point is if those video alternatives aren't developed, if that competition is suppressed, then folks like Google, who might want to provide a fiber alternative locally, may have fewer sources to which to go. And the whole investment decision by someone like Google, someone thinking about how to build out a fiber alternative to the monopoly internet service provider, may not want to do it. So it is really looking at that competitive dynamic at two levels, both at distribution and at content development.
And so if we're really talking about then the importance of the broadband market, so we have antitrust law, but does that mean, all right, we need to bring back the Ma Bell regulation for broadband? If broadband is the key, then why not go whole hog and bring back the regime that you grew up with as a young lawyer?
Yeah, and how well did that work for us, right? With everything, all the innovation just in the Bell Labs, and they dribbled it out when they were ready to dribble it out. I actually think, again, it's the way Tom Wheeler framed it up. If you try to find ways to promote competition, you're actually going to get, and I think what we've seen over the last 20 or 30 years proves it out. The Antitrust Division takes some credit for its breakup of Ma Bell. It actually provided more opportunity for us to, to take advantage of the video Moore's law. I think the right way is to look at regulation as a light touch in areas where there are market imperfections that cannot be enforcement, but always thinking about letting the market address the problem, solve the problems, let kind of the down and dirty nature of competitive markets make the difference.
Right, although on the other hand, we've all then going in the opposite direction. No, we've been saying for years, look, we need another pipe into the home, and the question is wireless that pipe, right? Lots of people in this room are now using, well, or at least their children are probably wireless only, and using Wi-Fi, and don't have any concept of any wires going into their parents' house other than to steal their parents' passwords. And so why not see wireless broadband as a complete, full substitute for fixed broadband?
It's a great question, but I think the answer for today is it's just not. We don't have the spectrum. It's too clogged. It's too costly, and so it is not really today or in the near future an adequate substitute for the current internet service provider.
Well, you say in the near future. I mean, there is the spectrum auction coming up, right? And so, with Antitrust, there'll be a lot of spectrum, coming online. Although, also true with DOCSIS 3.0 that unlikely that the wireless is going to hit those kinds of speeds, I suppose.
So we see as antitrust analysts markets that change over time. And I was at the FTC. One of the big matters I worked on was the challenge to Staples' attempt to acquire Office Depot. 15, 18 years later, Office Depot and Office Max want to combine, and the commission saw that the competition wasn't just, in fact, had moved from just big box stores, had moved to online, and then you look at the market differently as markets evolve. But you don't make decisions today that things in 5 or 8 or 10 years might be better, decisions that basically would put consumers at risk during that transition period. There may be a point at which you will look at these markets as one or as increasingly emerging. I just don't think we're there yet.
So my last question, John Salad, I think is somewhere.
He's hiding, but he's
hiding back.
Yeah.
In there. Right.
Yeah, right.
Right. Exactly. So we talk about everybody in this town always says we're all working together, we're all cooperating together, right? Just like on the on the floor of the house, it's my good friend so and so, and my good friend, even though you stick a shiv into them as soon as they walk off the floor. I'm actually, I know you wouldn't do that with John Salad, but I actually am interested in so we have, fine, there's cooperation between the FCC and the DOJ Antitrust Division, but it's also the case that you all have different roles and different mandates. And I guess I'm wondering if you can put a little meat on the bones of when you talk about cooperation with the FCC, what that actually entails, what that actually looks like.
Well, in order for it to be effective, you first need to recognize that, as you said, Stuart, the missions aren't the same, but we need to be able to talk about and recognize that there are differences. We need to talk at high levels, the policymakers. We have a regular dialogue. Tom Wheeler and I do. My deputies, Ron Hesse, Dave Gelfand, with Jonathan and his colleagues. But what's been really interesting is on a day-to-day level, we've actually crossed staff matters. We've had people from the FCC who've been detailed over to work with us on antitrust issues. We've sent people over there. We have one of our talented lawyers now working on detail over the FCC in connection with the Charter Time Warner deal. That it's not transformative, but it makes sure we're understanding differences in approach and the ability to communicate. On policy issues, the FCC will occasionally ask us for our perspective. So on spectrum auctions, we were glad to think about it and come in with a couple of comments during the course of that process. At the end of the day, this is a decision the FCC makes, but the fact that they're willing to sit down and read our views in connection with rulemaking, the fact that as we looked at the challenge, as I talked about in my remarks, of how one analyzes Comcast Time Warner when everybody knew the effect for most consumers day to day was they're still going to have one pipe into the home, and make sure we were talking about what the upstream effects might be, how we would analyze them. Just makes for the development, I think, of better public policy, better outcomes.
All right, well, in the spirit of cooperation, my implicit promise to all of you all is to have breaks between every panel. So in the spirit of that cooperation, we should stop here and thank Mr. Bill Baer for an excellent.
Thank you.